path to the bench was probably a little bit different because I grew up in a very, very rural part of North Georgia called Blue Ridge, which is in Fannin County, Georgia. And I decided that I was going to go to the University of Georgia because it was kind of a family tradition. And so I ended up deciding to major in political science, minor in English, because my mom was a public school teacher and she taught AP English in high school. And being back in my hometown, because that's where my family was from, there were not a lot of lawyers there. I did not go to law school to even be a trial lawyer, but I came back and that's ultimately what I ended up doing, was becoming a trial lawyer in my hometown, where I did that for about 9 years in a very small practice in rural Georgia. And then there was a position that came open for the Superior Court in our circuit. It's called the Appalachian Circuit. We have 3 judges, and I put in for that position. I had some really good friends say, you know, maybe you want to try and see if you can get appointed to this. And so I put that application in, and I was selected at that time by Governor Perdue, and I was appointed to be a Superior Court judge. And I stayed in that position for about 6 years before I came to the Georgia Court of Appeals, when I was appointed by Nathan Deal. The best part of my job is that I get to work with people from across the state every day, all day. Whether those are the lawyers that appear before us in the courtroom and we get to interact with them in the courtroom, whether that's judges from other classes of courts, prosecutors, district attorneys, private attorneys, public service attorneys. You know, it's very, very important in the judiciary that you have a clear perspective of where everybody is coming from. And the more that you come into contact with the public and the more transparent you are with the public, we have a better success rate, meaning that we can understand, you know, the problems that each of those different entities face. And so when those come before us, we're bound to follow the law no matter what. And our personal preferences and opinions don't matter, but we can understand where everyone is coming from. And I think that level of compassion and understanding is very important. So the best part of my job is getting to know the folks from across the state that appear before us, because at the end of the day, we serve them. We serve the people of the state of Georgia. We serve our communities, and we are public servants. And in order to be a good public servant, you have to understand the public, because quite honestly, nothing makes you feel the weight of the responsibility more than looking back at the chiefs that came before you and the leaders that came before you. I have been extraordinarily blessed to have been on this court with some incredible leaders. When I got to the court, then Chief Sarah Doyle was the chief judge, followed by Judge Dillard, followed by Judge McFadden, and followed by Judge Rickman. And I've gotten to serve with all of them for going on 9 years now. And I will tell you that the work that they have done is awe-inspiring. Each one of them strived every single day to make the court better than it was the day before. But they did that because they learned from everybody that came before them. So for me, my only goal is to leave our court as good as I found it, and hopefully better, so that who comes after me can build on what all of the judges throughout the history have put together.
You just heard from Amanda H. Mercier, Chief Judge of the Georgia Court of Appeals. And the reason her voice matters is because she understands the system from the inside. Not from theory, not from textbooks, from watching it operate. What Amanda is talking about isn't rare, it's routine. And now I want to show you exactly how that routine played out in one case. The Dexter Williams case. Let's start with the phrase most people skip past. Affirmed, opinion not published, Remittitur mailed. That sounds neutral, administrative, almost boring. But it's not. When the Georgia Court of Appeals affirms without opinion, here's what they're saying. We agree with the outcome. We don't need to explain why. We don't want this decision to create precedent. We don't want future defendants citing it. We don't want trial courts changing behavior. This is not about efficiency. This is about containment. Courts use affirmed without opinion for 3 main reasons. Reason 1, avoid setting precedent. If an opinion is published, it becomes law. Future courts have to follow it. And if that opinion admits a problem, a procedural error, a systemic delay, a rights violation, then the floodgates open. Reason 2, keep the same problems repeating. Unpublished opinions don't fix anything. They don't clarify the law. They don't warn trial courts. They don't change conduct. They quietly send the case back and move on. That's how the same issues show up again and again because nothing ever gets corrected. Reason 3. End the case without explaining it. Remittitur mailed is the court saying, "We're finished. Stop asking questions." Here's where this stops being abstract. Because Dexter didn't sit on his rights. He didn't wait years to complain. He didn't raise this late. Here's a timeline breakdown. December 22nd, 2020. Dexter files a statutory speedy trial demand after indictment. January 5th, 2021. The court denies it, citing COVID and the judicial emergency. But here's the key. Dexter doesn't stop. He keeps asserting speedy trial, before indictment, after indictment, over and over. Then comes the court's own admission. This is not speculation. The trial court later issues an order admitting it made a misstatement. The judge acknowledges that jury trials were happening before June 30th, 2021. So the idea that trials were impossible the entire time? That was wrong. And now the critical question. The emergency is lifted June 30th. The next trial term is July. So why wasn't Dexter tried then? Why not August? Why not September? Why October? That delay matters under statutory law. Here's where things get convenient. Before the issue can fully mature, before the old docket has to go up on appeal, the state reindicts. Now there's a new case number, a new procedural posture, and suddenly all those earlier demands, they're treated like history instead of law. That's not accidental. So Dexter appeals, and the Georgia Court of Appeals responds. They don't say he never filed speedy trial demands. They don't say the delay didn't happen. They don't say the judge didn't misstate facts. They say something else. You should have raised this earlier. Earlier than December 22nd, 2020? Earlier than repeated filings? Earlier than the docket shows? This is where procedure wins. Instead of addressing whether the statutory clock ran out, instead of confronting the July term, instead of analyzing what the reindictment did to those rights, the court shuts it down on procedure, and they do it quietly. No published opinion, no precedent, no warning to trial courts. This is why rights disappear. Not because they don't exist, but because procedure can kill them before anyone reaches the merits. And when courts don't publish opinions, the same thing keeps happening. Different defendant, same engine. In the next part, we're going to look at how this affects more than just Dexter. Because once you see the pattern, you can't unsee it. Lamar will be in later with a deeper dive in the Georgia Court of Appeals practices and further educate you guys on the importance of speedy trial. But until then, I am Mean Dog, your on-site reporter, reporting live from the Georgia Railroad. New media out.